Anyone in the class? Every group members of group 5 are in the class. Can you show your screen video for me to see? So I have Quang Vinh, right? Quang Vinh, Thúy Vi, and who else?
Dạ, Nguyễn Thị Thảo Vi.
Thảo Vi. Thảo Vi, have you turned on your camera? I can see V and Quang Vinh. Thúy Vi, okay, all right, okay. Okay, good. So now you can make a presentation, please.
Yeah.
Yep.
So welcome you guys come to the group 5 of our talk law. Today we have our group have about 3 members là Võ Thị Thúy Vi, Nguyễn Quang Vinh and Nguyễn Thị Thảo Vi. Today our group is a presentation about the case with the plaintiff David, a business executive, and we have 2 defendants. One is Peter, an irate passengers at the airport, and the security screening company, which he described as his slowness and incompetence. So to make sure you have all clear about this case, I will now summarize the case for you. Just about. So David is a business executive who fly often in a connection with work. So after the September 2001 terrorist destruction in New York and Washington, David is flew less frequently. So in response to the attack, a new federal regulation made the federal government responsible for all the airport security personnel. In most cases, including at the David home airport, the government met the obligation by hiring private contractors to provide the security service, and these firms were heavily regulated and controlled by the government. So also in the new regulation were providing guidelines that require additional security screening for persons meet such guidelines. These guidelines were partly secret, but it was known that members of certain race were much more likely to fall within them. In addition, on average, 6 times as many males as females missed the guidelines. So shortly after these regulations were in place, David went to his airport and found an extremely long line at the security checkpoint, and he waited in line nearly 3 hours. So as he's about 10 people away from being screened, an irate passenger, Peter, came running through the line, screaming that he was about to miss his flight. So Peter accidentally hit David forcefully, breaking David's arm. And in addition, David has hit Ferd in his coat pocket, and this impact caused the Ferd to die. Peter said that the slowness and incompetence of the security personnel had caused him to lose it. So when David checked the security checkpoint, he was pulled aside for additional screening. This involved waiting in an additional line for 30 minutes longer. David learned that he had to go through this additional screening because he was returning home on the same days, had no checked baggage, and was male. So David had sued both the security screening company and Peter for his injuries and the loss of his fur and emotional distress related to these. So the question here is applying US law to discuss David's claims. any defense and their likely resolutions? Would it be different if Vietnamese law applies? So here, after understanding the case, we clearly see that we have two defendants. One is Peter, one is the security screening company. The legal issue here can be easy to see that we apply the US law with whether Peter is liable for negligence and whether the security screening company is liable for strict liability or abnormally dangerous activities. We will both applying US law and Vietnamese law for two defendants here. So with Peter, I have a chance for TV. So now continue our presentations. TV, are you ready?
Okay, I'm ready. Can you hear me clearly?
Yeah, I can hear you. So let's start it.
Okay, I present the problem on behalf of my group on how to solve the faulty that Peter caused. In my presentation, I will divide into 3 parts for everyone to follow. The first one is identify Peter faults for David. The second one is determine Peter's responsibility for killing David Perez. Then the last one is compare responsibility with Vietnamese law. And the next slide. Okay, in Peter's case, our group determined that Peter committed the offense due to negligence. The person who caused the accident is considered negligent because they failed to exercise the same degree of care that a reasonable person could have in the same situation. Someone is negligent if they unintentionally cause injury to someone in a situation where the reasonable person would have been aware of the action enough to cause harm. So, for the negligence, there are 4 elements are required to establish the negligence. Someone help me to tell the 4 elements to negligence. Someone volunteer? Hello, everyone. Okay, if no one to volunteer, I want to invite Hoàng Yến. My friend Hoàng Yến, can you tell me 4 elements to establish the negligence?
Yes. According to what we have learned, I think there are 4 elements of negligence. First of all, the dependent on a duty of care to the plaintiff. The defendant which the duty of care. The next is that the plaintiff suffered injury or damage, and finally, the defendant's negligence are caused the plaintiff injuries or damage.
Are you sure?
Yes.
Okay, thank you, Hoàng Yến. Did it exactly. 4 elements is first one, duty of care. The second one, breach of duty of care. The third, damage occur. And the last one, the causation relationship between the violation and the damage occur. That means causation. And without one of 4 elements, this responsibility does not exist. Okay, we will explore each element in turn. Okay, can you back on? For duty of care, mean that any single person must always take responsible care so that he can avoid omission and act that he can foresee reasonably as likely to result in injury to his neighbor. In this case, we can define the duty of care between the Peter and David. is who are in the line with the close contact. In addition, to find a duty of care that is it, that duty of care is then have to reasonable standard. This means that David proved to the court that it was reasonably foreseeable that an act or omission could cause damage or injury to him. In this case, Peter is complaining about missing his flight, but Peter is obligated to take steps to ensure that damage does not occur. But while pushing the line, Peter accidentally hit David's arm. And when Peter wants to cross the line, he must pay attention and must take responsible. Must reasonable step to avoid harm in case of debt obligation. So we can conclude that Peter accidentally hit David and break David's arm, causing failure in both cases. Mean Peter had breached his duty of care. And so can we show the next slide? And for caution, the third element of negligence is the caution. Cause require the plaintiff to rule that the defendant breach of duty were the cause of plaintiff injury and loss. Another thing to consider is whether the defendant could have foreseen that his action could cause injury. The actual causes that exist in this case is Peter knew that crossing the line and going so fast could cause injury to others for not complying with the line. Peter, while crossing the line, hit David's arm, causing David break his arm, and the broken arm is logically related to the Peter breach of duty of care, because if Peter had lied like everyone else, he wouldn't have hit David and broke David's arm. Okay, and the last one is damages. Damages is an intermediate element for negligence. We can see obviously that the physical injury that the David's injury was broken arm. So the monetary compensation may be the one form for release of such injury. Damage may be in lieu for medical care, emotional turmoil, and more. So we can include that or conclude that Peter is full of violation element due to negligence. And for the second part is the determined Peter next for Peter's responsibility for killing David Perez. So David can show Peter for killing his company animal by negligence, but David must demonstrate that Peter had a duty to be reasonably careful, and Peter failed to meet that obligation, and the cause harm to David as owner of the property, because animals are considered to be a property. Injury to animal is not enough. If Peter had not crossed the line and complied with the line, there would have been no collision, and the impact would have killed the parrot. The harm is usually in form of the cost of releasing kill animal. And how about the David's case in the Vietnam? Okay, legal issue in the Peter case under Vietnamese law is whether Peter is liable for negligent like is US. In David's case, Peter could be charged with unintentionally causing injury or harm to another health under Vietnamese law. This is an act of unintentionally causing injury or causing harm to the health of other with injury grade 31% for more. This crime specified in Article 138 of the Penal Code 2015. The crime of unintentionally caused injury or causing harm to health of other is specified in Article 138. Can you see this law? Okay, next slide. For accidentally causing injury or harm to the health of another person is understood as a negligent or overconfident act, result in injury or harm to other health. To analyze the crime of unintentionally causing injury Vietnamese law, the first one is legal side. The object of impact is a human. Objective is the act of the causing injury or harm to health of others. This is a case where the offender acts in violation of the safety rule for health of others. Consequently, causing injury of harm to health of others with infirmity grade of 31% or more are mandatory side of this crime for the subjective inadvertent error. And the object of person who fully capable of a penal liability and breach the act of 16 year or other. And the second is penalty, who those who unintentionally injure or cause harm to the health of others with an infirmity grade of 31% or more shall be subject to warning, non-custodial reform for up to 2 years or a prison term between 3 months and up to 2 years. And offender may also be banned from holding certain posts, practicing certain professions, or doing certain jobs for 1 to 5 years. So at this time, David needs to call for injury assessment disability and send the denunciation to the police agency to propose the prosecution of the criminal case and claim compensation for damage in accordance with the law. And the last one before David Pett, we can see the Article 105 regulate about the property. So animal are one of the type of property specific Article 105 of Civil Code, because animal have common characteristic of the property, such as belonging to the physical world, being a human possession, having value, being able to be the object to exchange in transaction, and basis for the arising liability for damage compensation in the Article 584, we can conclude that according to the clause 1, it is stipulated that any person who commits act of infringing upon his or her life, health, honor, dignity, reputation, property, right, etc. If someone else causing damage, they must compensate. Bitter behavior here can be understood as an act of person who has infringed on another person's property and has committed an act. That person will be at fault. Specifically, the fault is unintentional infringement upon the health and property of others. And that's all for my part. And the next one is about the green security green company. This one is part of Thảo Vi. Thank you for listening.
Yeah, hi everyone. Now we move to the next legal issue, whether the security cleaning company is liable for strict liability of abnormally dangerous activity, and activity is considered abnormally dangerous if it, one, activity must create a reasonably foreseeable risk of harm, but secondly, the activity is not the matter of common usage. The next one is activity involves a high degree of risk of harm which cannot be eliminated by the exercise of reasonable care. And finally is the activity is not appreciated to the place where it is carried out. I will discuss and analyze one by one before I go to the conclusion. The first element is, activity must create a reasonably foreseeable risk of harm. And here, obviously, David was a foreseeable plaintiff, and the harm he suffered could be foreseeable because the security service was slow and incompetent. When David went to the airport, in fact, extremely long lines at the security checkpoint, and he had to wait in line nearly 3 hours. And so we can see the crowds and chaos in the security areas, which can be easily drive people insane. And most defendants, the security cleaning company actually knew about the risky of their actions of these activities. So we can see the risk of harm in this case. So I think this element is satisfied. Next to the next element is the activity is not a matter of common usage. An activity will be considered of common usage if a significant part of the community engaged in it, and it is obviously that the activity is not the common usage because it had not carried on the airport before the September 2001. So it still before it still had the airport screening, but it's provided by the private security companies, not belongs to the government. So and actually before it's not had been intense like after the September 2001. So I also think this element were also satisfied. And now we move to the next element. This activity involves a high degree of risk of harm which cannot be eliminated by the exercise of reasonable care. This activity didn't involve a high degree of risk of harm, and obviously it can be eliminated when the exercise of reasonable care, because in the airport we have security, so it's really difficult to cause dangerous risk of harm. And besides, if the security company works faster and more competent, this damage could not have happened. So I think this element is not satisfied. And the last element is also not satisfied because it's required the activity is not appropriate to the place where it carried out, but this activity is appropriate to the place where it carried out, because after the September 2001, the destruction, the terrorism in the New York and in the US, the government had to hire the private contractors to provide a security service, and this company belongs to the government, not the private company. So our conclusion is, and I also think this is not satisfied, and move to the conclusion. Could you next? Yeah, thank you. Now we move to the conclusion. We just proved 2 of 4 elements is satisfied. So David cannot sue the security cleaning company under the strict liability of abnormally dangerous activity. It means that the security cleaning company is not liable for strict liability. Now I will analyze and discuss whether the security cleaning company is liable for loss and damage caused by infringement of David's interest under Vietnamese law. I will prove it through the article 608 of Civil Code. It's say a natural person or juridical person carrying out production or business and failing to ensure the quality of goods, thereby causing damage to the customer, must compensate for such damage. So you can see this article, there are 2 elements that I have to prove here is whether the company failed to ensure the quality of goods of service and whether it caused damage. It caused David's damage. So firstly, I will prove whether the security cleaning company failed to ensure the quality of service. Yeah. Now we can see because of the slowness and incompetence of the security personnel. But actually, this action actually failed to ensure the quality of service because I am Soviet in Vietnamese law, so I will show this law in Vietnamese on the slide. According to Clause 5 of Article 41, this means that 100% of passengers shall undergo cleaning before entering the retreated area, and if people who refuse to undergo cleaning will be refused to permission to fly. So obvious that David had no choice. The crowds of security areas is hard to avoid, so David cannot blame the slowness and incompetence of service to sue the security cleaning company. So the slowness and incompetence of security service is not considered to fail to ensure the quality of service. And the next is he will pull the site for additional cleaning. According to Article 8, according to Clause 8 of Article 41, it means that if the passenger, when a passenger walks through the helmet, walks through the first security service, and if they have any suspicious sign, and the security control staff can use the high helmet detectors or conduct an additional check at the same time. But we can see the suspicious side. So the question here is whether the David show any suspicious side, and more importantly, suspicious side is not defined on this law, and there are no definition of it, and there are no definition of suspicious side, and there are also not identify the suspicious side. So when we think about the suspicious side, it can be the people behavior, but they may be the fearful and they may be have a fearful and a fearful anxiety. But in this case, the reason why, yeah, next slide, please. Yeah, and in this case, the reason why David had to go through the additional security because he was returning home on the same day. He had no checked baggage and work mail. But I think the actual reason here is David is a member of certain races. So I think the company, they think the members of certain races much more likely suspicious side, and the member of certain races had to go through the additional security, and this reason is police secret. It's not the public, so David don't really know the actual reason why he had to go through the additional size, the additional service. The additional security. So just the staff, they know this reason, and so I think it's not considered as suspicious side because David didn't show any signs of suspicion and danger here. And if they based on he's a member of races, I think it's kind of this discrimination here. So I think this activity of staff is considered to fail to ensure the quality of service. But however, whether this action cause damage, as I just mentioned, this action he had to go through that additional security is considered to fail to ensure the quality of service. But this action happened just after Peter hit David, and Peter broke David's arm and caused his pet to die. So this damage happened before he went through the additional cleaning. So I come to the conclusion that the security cleaning company is not so the company failed to ensure the quality of goods because the staff forced him to go through the additional security without any suspicious sign. But they not cause damage of David. So
I think the security cleaning company is not liable for David's loss and damage. So that's the end of my group presentation. Thank you for your attention. If you have any questions, please feel free to raise your hand. Thank you.
Okay, everyone. So anyone have any questions with respect to the representation? If you do not understand about any facts, okay, please raise the question. If you do not agree with any of their conclusion, okay, or you want to suggest something else, okay, you can raise your voice. Anyone have any questions? Anyone? Hello, Rafai. Have you sent me your submission, the slide? Hello? Do you hear me?
Yes, Miss.
Yeah. Did you send me your submission, the slide of your presentation?
Yeah, no, actually, we don't know how to send the slide.
No, I already asked every group. Every group send their submission to me.
Yeah, sorry.
Please send it right now because I need to look at several of your slides.
Yeah,
Miss, we are group 3 and we had sent the slide for you on Monday for the presentation on Wednesday. But however, on Wednesday we had a delay to Friday today. So we also had made some alternation. Do you want us to resend the slide for you?
Yeah. I in fact see your slide on actually the 14th of December. But if now you want to resend the slide that you used to present today, is it okay?
Okay. Then we will resend to you.
Yeah. I already got the group 4 submission already, but group 5 I haven't received. Group 5, please send it to me. You sent already?
Yeah,
Yeah.
I'm sending.
Okay.
Yeah, I have just sent you our presentation. Please check your
Okay. Yeah.
email. Thank
Yeah.
you.
Check it right now. Okay. Yep.
Sorry.
Okay. Okay. I got your presentations slide already. Yep. So if no one have a question for this group, I will have a question for you. Okay. So in your group's presentation, okay, you said that the legal issue is whether Peter is liable for negligence. Okay. And the second issue is that whether the security screening company is liable for strict liability of abnormally dangerous activities. So that is the two legal issues that your groups is actually put on your presentation. Okay. And no one in the class have any questions about that? I just want to share my screen because it's easier for me to move from one slide to the other slide. Here is the slide of the group. And it say about the legal issues is whether Peter is liable for negligence. And the second one is whether the security screening company is liable for strict liability of abnormally dangerous activities. So that they're legal issues. You didn't put the full questions that I gave you in the slide, right? Remember that I already, maybe your group didn't pay attention when I give an instruction to the presentation. For the instruction, when I give an instruction, I already clearly say that in the first slide, you should say about your group name, group member names, student IDs, who is the leader, and the next one, please pay the full question, the full problem that I send you. Okay, and also I request that every group need to submit the presentation to me on before the date on what your group make a presentation, but this group didn't follow that. Both requirements. The first requirement is that the full questions, and the second requirement is submissions of the presentation. So you did not participate in the section that I give the instruction, isn't it? Wasn't you didn't, right? You didn't participate.
Yeah, Miss, can I say something?
Yep.
Your full question I have put it at the end of our summary of the case. A summary
At the
of the
end?
case at the end of the summary of the case.
At the end of the summary, which slide?
Yeah, you can pass for about slide. Yeah, under the slide of the man is thinking. Yeah, slide 13.
But remember that I already told you that the full problems, not about the question, the full problem, and it must be on the second slide. The full question that I send you, not about just only the question, but the full case that I emphasize. The reasons is that because sometimes people summarized the case, and when summarizing the case, you miss some important information. So that's why I need the full question, the full problem questions that I send to the groups in order for other members in the class to follow. So here is the full questions of the groups. You see the screen, everyone? You see my screen?
Yes, Miss.
Okay, so look at the screen, please. And whether you agree with the legal issues that profile raised. Everyone, do you have any idea? No one have any idea? You think the normal tort of negligence or what? Look at the last parts. David has sued both the security screening company and Peter for head injury and loss of his parent and emotional distress related to this. Anyone have any idea? Anyone have any idea?
So when David sued both the security screening company and Peter for his injuries, is it joint liability?
Maybe we do not have to consider about Troy liability, because if you say Troy liability and they will share the damage, we do not care much about that. But what we more care about is that what type of tort that he can take legal actions against it of the company, it of them, it of the defendant, and whether the defense available, what specific types of negligence, what specific type of tort generally.
Okay, I understand.
Yeah. But the type of tort must be specific.
Miss,
Yes,
is can be gross negligence.
I don't think so. Gross negligence requires that you know that thing could happen, but you think that you can overcome that.
I have a question related to the case. Is David is within the class intended to be protected? That's why he go through the additional security check.
Your question is not very
My
clear about your questions.
My question is David the person within the class that is intended to be protected?
Protected by what?
Because the additional security is established after the terrorism in 2001. So I don't quite understand the purpose of that additional security when it is established after the terrorism.
But you asked that for what purpose?
I asked that for the purpose of categorizing the negligence, whether it's for under the negligence per se.
Negligence per se, when there is the statutory law that, so negligence per se is actually allow people, that prohibit people from doing something that against the law. I can't see it's relevant in this case.
Okay, my bad.
Yeah.
Yes, Miss.
Yep.
Yeah, I think in this case, the specific negligence here is contributory negligence.
What negligence? What type of negligence? Again?
Contributory negligence.
You want to answer the question? It's not very clear for me that what types of damage, what types of negligence, what special type of negligence that you can considering. You look at the words, he want to claim for head injury and the loss of his parents.
So that is the negligent infliction of emotional distress.
Emotional distress. Okay. Emotional distress. Yeah, negligent inflictions of emotional distress. But can he be successful? Yes.
I think that David can be successful in claiming damages from Peter because the group has also proven that Peter has the duty of care and Peter has breached his duty of care towards David, leading to David's physical injury as well as personal injury, which is his parrot death. And especially in US law, people usually consider their pet as a friend. And
yeah, I understand your view, but I just want to ask, when you apply the law, the rules, you should use the elements of the tort rather than what you think. Okay, that is the differences between applying the law and resolving the problem from a social aspect. We are resolving case based on the law.
all right.
Yeah.
So allow me to
Yep.
say it again.
Yep, sure.
So we have 4 elements needed to be proven. The first one is duty of care. The second one is breach of the duty of care. Number 3 is the injury and damage that the plaintiff has suffered. And the last one is the causal link. So throughout the presentation of the group, they have proved the duty of care as well as the breach of duty of care of Peter. And we have a clear view of David's injury here is that David has his arm broken and his pet died. That is related to physical injury and personal injury. And the causal link is very clear that because Peter running through the line, screaming, and hit David, leading to David's arm broken and his pet death. So we also have a causal link, and they are all qualified and valid to say to prove that Peter was negligent and David is has the all ability to claim for damages for emotional distress also.
Okay, so you think that she can successfully prove that he can successfully sue Peter, right?
Yes.
Yeah, for negligence inflictions of emotional distress.
Yes.
Okay, so whether the ferret is a close relative of a person,
so this question is not provided in the fact, right? The answer to this question is not provided in the fact, but we
no, that is the normal question. Yeah, you need to consider because the first elements that help you to claim under negligence inflictions of emotional distress is that you need to prove that first of all you witnessed the accident happen to your close relatives. So whether the Pharisee, David relatives, in order to satisfy that requirement. Okay, so he may claim hit injuries against Peter under normal negligent case, but not in the case of negligence inflictions of emotional distress because the ferret is not for the loss of his ferret because the loss of his ferret is not his relatives. That one reason. The second reason is that he may not be able to claim the loss of the ferrets under the normal tort of negligence as well because of what? Anyone know? Do you think that he could be able to claim against Peter under normal negligence case for the loss of his parent? For normal negligence, he can claim hit injury. Yes, right? You can prove based on the facts because Peter was in a hurry and Peter hit David, breaking his arm. All right?
Um, um, I I see in I see in the voluntary mount bracket. I don't know how to say it, but this one by that cost is
In what?
almost
In what? In what?
um I should copy it.
Yeah.
I don't know how to say it. Sorry.
But just explain. But just explain what the court said. What the court said.
The court in almost all the state in the U.S. don't allow compensation in negligent cases for the emotional harm of losing company for pets or seeing them suffer. That
So,
means
so what is your conclusion? I'm not very clear.
um,
Is it not allowed or allowed?
I mean in the David for it the court judge không David must require Peter to compensate for loss animal by replay a cute animal replay new parrot and for the emotional harm of losing the pet the court don't allow to compensation for negligent case that
Okay, all right.
yes
But even for the loss of the pet,
yes
physical,
just
can he claim?
claim for the cost for
Yeah, the cost of replacement of the pet, right?
yes but
Yeah,
the,
what you
the
think?
emotional is the stress enough they don't
Yeah.
allow but
We agree on that. We agree on that already. But I just want to ask you in this particular case, remember, can he claim for the cost of the parrot as well? You look at the facts of the case.
I think in this case, David can require for compensate the loss of the ferret.
The loss of the ferret. Okay.
Yeah.
Anyone else have different idea about that question? Do you think David can claim the cost of the ferret under normal negligence case? Anyone can let me know whether you think yes or no and based on what facts of the case. We are about to finish the class, 12 o'clock already. Anyone know? Okay. You know where the pet is? Where the pets?
In his coat pocket.
Yeah. Can Peter know that?
No, I don't think Peter were.
Yeah. So what elements is not satisfied for normal negligence?
Is the reasonable person?
No, it's about the foreseeable.
Foreseeable consequence.
Possibilities. Okay, you look at the causal link, and there is a causal actual cause and proximate cause, and this in this case, the loss of the ferrets cannot be foreseeable by Peter, right? Because Peter is not possible for a person, normal person. You can apply also a reasonable person test in order to find out the foreseeability. A normal person in such a situation and circumstance, circumstance cannot be foreseen. Understand, everyone?
Yes, Miss.
Yeah. So you need to examine all of the fact givens, okay, in order to explain. Is it not very important? For me, it's not very important for whether your conclusion, what your conclusion is, but what's more important is that you take into account all of the relevant facts, okay? And you also consider all of the relevant facts, raise issues, point out what are the relevant thoughts that could be used, etc. So that's what I want you to do. Okay, everyone?
Yes, Miss. I understand.
Okay, thank you. As long as you understand what I am explaining, and it's good. Okay, you improve, and then you can improve, and you can have a better mark in your final examination, because the final examination you will be given problem solving questions as well for you to resolve. So as long as you can take into account all of the relevant facts, as long as you can point it out the most relevant types of thought, the higher mark you can get. Okay? Understand?
Yes, Miss.
Okay, thank you. Thank you, everyone. See you on next Monday, is it? Or no? Or sometime next week?